Listen, Operation Kulula Judge, okay, was in full force, okay? Operation Judge, be reminded of your powers, of your duties, reminded of why you are seated and elevated in that room was in full force. As Umnisi stood up to say, this is nonsensical. I cannot stand this anymore. This mere policeman is really, really getting on my last nerve, and I tolerated it on Monday. Now Ngomezulu is gone, okay? Did not show up. We are just assuming the doctor said don't go back there, because who the hell really wants to sit through Gininda acting as a whole prosecutor when he is a mere policeman? And then Mshololo stood up and said, I stand in solidarity with my learned colleague. I stand in solidarity with him. How on earth is Brigadier Gininda jumping to bring us hearsay from a man who has passed away? May his soul rest in peace. My Lord said, Zwi. Okay, and then Baloyi said, you know what, I'm going to ignore them and I'm going straight back to, let's start with what you were going to say about accused number 2. And then Brigadier Gininda said, how dare you, Baloyi? How dare you let your mere learned colleagues speak to me in this manner and try to move past this? I will address this myself as a whole brigadier running a cold case unit that nobody else knows about. And then Gininda addresses Umnisi and says that was disrespectful, Ntoni, and he goes on and on and on. Listen, it was the battle of the giants in there. If you thought the battle between Umzilikazi was what, it did not amount to anything, okay? It did not amount to anything when it came to Brigadier Gininda addressing Umnisi. You would expect the judge to say something. The judge said, sweet. When the judge realized that Brigadier Gininda has taken over and is showing and flexing his muscles in his courtroom, the judge himself, for the first time ever in the history of the SENZO MEYIWA trial, said, let's take a tea break. Hello everybody, welcome back. This is Mzansi Unfiltered. If you missed this war zone in Judge Ratha's courtroom, because let me tell you something. Today, Brigadier Gininda showed his colors and that he runs the courtroom, okay? He runs the courtroom if nobody knew. Even Judge Ratha said, and is he? And he ran out of that courtroom and said, let's go for tea, because what in the South African Police Services, Brigadier Gininda, is going on in my courtroom? But I'm not going to ever address Brigadier Gininda. I'm not going to do it. I am not going to do it. The advocates are absolutely right. But I refuse to descend into the arena. Let's go on tea break. So they went on tea break. If you missed all that exchange, I'm going to clip it right here. I'll be back with the rest of your commentary. Well, I'll be back with the rest of my commentary. Be sure to share with me in the comment section what was your highlight between that interaction.
And this, my Lord, as I've said, is in addition to the neighbors, the witnesses who witness people running out of that house after the shooting. So taking that information, which was disposed in the form of a statement, I couldn't ignore the fact that the only inclination or direction is that indeed there were intruders, because this is independent from the people who were inside the house, who were then questionable at that stage that perhaps were they telling the truth or not. These are independent people. These are police officers who were in duty, who simply responded to the crime scene, my Lord, and this is what they were informed. They documented what they were informed. They had no reason to mislead. And the neighbors and the people who also indicated that they saw people running to a certain direction, they were not part of the people who were inside the house. Those were simply eyewitnesses and neighbors who simply indicated what they observed, my Lord. Yes.
Thank you. Now, Brigadier, if we can now deal with accused number 2.
Sorry, before you start, I'm sorry. You said neighbors. There was a neighbor you said in the evidence. They say that neighbor passed away. It's Mr.
Ngasha. Yes, yeah, the senior the
The
fund.
senior. Was he a
Yes.
policeman or what?
He was a warrant officer, was
A
a
warrant
police
officer.
officer, yes, and
A
then
retired warrant
he
officer.
retired warrant officer, yes. He
Yeah,
disposed
sorry.
an affidavit, and also the same indication was given, my lord. And my lord, further one can say that in dissecting this, because at that stage it was almost like a fact-finding mission for me, because you see with this matter there are sort of two. You have obviously what is contained in the docket, but there seems to be this theory or assertion or allegations, if I can put it that way, that there were no intruders. One needed to dissect what was contained in the docket factually, not on allegations or theories, on hearsay, on the facts that were contained in the docket. And the facts contained in the docket, my lord, indicate what I've informed the court, that there were independent witnesses other than the people who were in the house who saw people running out of that house. No one could say that the people who ran out of the house were actually the same people who were in the house. They ran, a description is given by the neighbors who were outside. That description, particularly of one of the shooters with the dreadlocks, is also given by the people who were inside the house. So there you find a common factor that there was a person described with a firearm inside the house with dreadlocks. The neighbors, particularly the lady that was sitting outside, I recall that saying she saw when they were running away that one of the suspects had dreadlocks. Now, you have to take that objectively, my lord, not in terms of hearsay, objectively. In addition to that, my lord, I've said objective evidence, which is DNA, that was found at the crime scene, excluded everyone that was in the house. What it indicated is that that DNA was left by someone else other than the person who were in the house, the persons who were inside the house. That DNA was obviously at a later stage, my lord, when these accused were actually now targeted. Their DNA were taken for comparison. I suppose when we get to that stage, I will deal with it, my lord, because as much as certain findings were made by the specialist, but they were pointers by the specialist to say there are common things that you can find on these people. And for me as an investigator, it was good enough that even if it's 1 or 2% of the DNA, for example, pointing accused number 3, it is enough for me to convince me that he was there as an investigator.
Objection. That is not his terrain. It is exclusively not his terrain. He's repeating the very same thing that I cautioned about. Mr. Gininda is not here as an expert, madam. He's here as a police officer. He only needs to bring information to the court, the basis on which this court then will have to make a decision. He is not here to analyze that information as though he's the one that is going ultimately to give a judgment. He's pretty wrong, and the state is allowing to do that. I don't know if the state is doing that with a view in order to influence the mind of the court. But I'm very grateful because the court said earlier on that the court is well trained and it is experienced enough to separate the wheat from the chaff. What Mr. Gininda is doing now is only trying to influence the mind of the court with a hell lot of a chaff. What is stating now is a chaff. It's nonsensical. It should not be done, my lord. And I'm going to request the state to tell its witness to refrain from what the state's witness is doing, my lord. Because it's not here as an expert, and we're not interested in his opinion. His opinion matters not. Ultimately, it is going to be the duty of the state, on the basis of the evidence that Mr. Gininda would have submitted to this court, to argue what he is now trying to argue. Otherwise, Mr. Baloyi needs to get into the box and Mr. Gininda come into the point where Mr. Baloyi is standing. They need to swap positions. But what he's doing now is pretty nonsensical, my lord.
Okay, yes, let's hear the state. What's the state's
As a good
response?
please, my lord, I think very fresh on the article that the court referred to about courtesy in court, one would have expected Advocate Mnisi to refrain from using words such as nonsensical, no matter how strongly he might object to the evidence. I think there's still a duty to show courtesy to the witness and the court. That is the first thing. The second thing is the court had asked this witness a question in elucidation, and the witness was in the process of answering the question that was posed by the court. And thirdly, as Advocate Nisi pointed out, that the court has mentioned that it's trained to separate evidence from opinion evidence. Thank you. The state will request that those gratuitous and unbridled insults by Advocate Nisi regarding the witness be ignored, my lord.
It is no insult. The word nonsensical is there in the dictionary. If Mr. Baloyi is not aware of it, I can refer him to that word. And the definition of that word simply means that it makes no sense. It is nonsensical. I don't know how insulting that word is, man. And I heard him mentioning that there's an article on a Sunday that he read regarding court ethics and stuff like that. That starts with him. He knows what a duty of a witness who is an investigating officer is when that witness is giving his evidence. It is Mr. Baloyi's duty, first and foremost, as a leader of that witness, to lead that witness specifically on what that witness should come and tell this court, not to allow that witness to be on an escapade and wantonly come and give evidence that it is not in his terrain to come and give. Mr. Baloyi has been allowing Mr. Gininda to give opinion evidence. Mr. Baloyi has allowed this witness on a number of occasions to come up with suggestion that the evidence that is already before court demonstrated that accused number 3 was involved in this matter. He now mentions DNA. Previously, he also mentioned a firearm. It consistently allows this witness, my lord, to go on an escapade, on evidence that it's, at this stage it is inadmissible. It's basically giving this witness a role that he himself should actually be playing. For instance, the court has simply asked a question about Mr. Ngachi, whether or not he was still alive or what. This witness now goes out of the rail, it goes out of the question that the court has specifically asked, and Mr. Baloyi allows that to happen. And then he stands up and says there's an article that has been written by the honorable judges of this court on how ethics is. I am not here, my lord, representing myself. I am here to represent the interest of accused number 3. And I cannot allow witness such as evidence such as the one that is coming from Mr. Gininda to go through the record and miss it down here. I'll never allow that, my lord. Otherwise, I'll be doing injustice in the representation of Mr. Mngube here. But first and foremost, it starts with Mr. Baloyi himself. Okay. Thank you, my lord.
To save time, my lord, we'll then proceed. I've already mentioned that the witness was commenting on the question that was asked by the court. We had already moved to the situation of accused number 2 when the court asked this witness to comment on something. We cannot interrupt the witness when he answers to a question that was answered by the court and to which the court is entitled to ask. That is the simple fact of the matter. And as we pointed out, my lord, we don't understand the objection that was raised by Advocate Nisi, as the court pleases.
I will make declarations and conclusions regarding the evidence tendered in this court, whether that evidence proves or disproves anything. And I'll quote the reasons why, if I agree or disagree with that evidence. Okay.
Thank you.
Mina-ke uzothatha-ke isinqumo-ke ukuthi-ke ubufakazi obethulwayo-ke lobo bufakazi buvumelekile noma cha, ngizosho futhi-ke nangokomthetho ukuthi umthetho uthini mayelana nalokho.
As the court pleases, my lord, I agree with the court on that it is the duty of the court to analyze the evidence, my lord, at the end of the case. However, my lord, I'm also standing on the point of objection so that it will go on record that it was pointed out, my lord, during the trial stage, that the way that the evidence is elicited at this point in time is not the correct procedure, my lord. Especially, my lord, the reference that has been made by the witness to the Ngashe senior witness, my lord. That statement was never handed in this court. There was no application for the handing over of that statement as hearsay statement. So in other words, my lord, it is not proper before this court. And the witness has made reference to the content of that evidence.
Yeah, no. Where do I get the evidence? I got the evidence here.
Yes, my lord.
When I came to know that there's a neighbor who has made a statement, who actually also had a commotion, and there's another neighbor also who saw the deceased with his back in a white skipper or sweater,
Yes.
in the kitchen and had commotions. Somebody jumped into the yard and ran outside again. But the evidence of being a policeman who was there, I heard it from here. Am I right or wrong? I mean,
Yes.
how would I know otherwise?
For the one for the police, my lord, I don't have objections because those police testified.
No, Mteto and that gentleman, I don't have
Yes,
a problem.
yes, my
I
lord.
mean Ngashe.
Ngashe,
Because
yes,
I
my
wanted to
lord.
know where Ngashe is.
Yes.
And I was told that he's deceased.
Ngashe is deceased, my lord, and his statement was never submitted to this court as evidence, my lord. And therefore, no reference should be made to that statement or can be made to that statement, my lord.
When you say no reference should be made to that statement, no reference should also not be made to the evidence of the son of Ngashe. What's his name, by the way? Kaya. Kaya said, I was with my father. You remember that evidence?
My lord, the son is alive. The son has testified.
You don't know what I'm getting to, you see.
Oh, sorry, my lord.
The son also spoke about the father
Yes.
having seen whatever.
Yes.
That's all. And then the
Yes.
father is dead.
Yes, then let's correct the record, my lord. If we are making reference to the evidence of the Ngashe's son, then it must be directed to that portion of evidence that Ngashe's son said 1, 2, 3, 4, and 5.
Okay.
But reference being made to the statement made by Senior, who passed away, and his statement has not been submitted as evidence. My lord, I'm raising an objection
Okay,
on that
fine.
point only.
Fine, okay.
Yes, my
Let's
lord.
go on.
And then also, secondly, on the issue of this witness giving analysis or making reference to the expert evidence, my lord, which is the forensic evidence which was led in this court, who is now saying, out of that expert evidence, I can be able to say 1, 2, 3, 4, and 5. He's not an expert, my lord. He's not allowed to make any reference and to analyze on that part of evidence. He's just a police officer, this one. As the court pleases, my lord.
All right, yes, Mr.
As a court, please, we really don't, the neighbors that the brigadier is referring to have already testified, Ms. Nthabise Mokete as well as Ms. Kaya Ngashe. The evidence is already on record. As far as the analysis is concerned, the witness is merely saying that those are, the expert has already testified. The DNA analyst has already testified. The witness is merely giving a summation of the reason why he was persuaded that there were no, that there were intruders. That's the simple fact
Okay.
of the matter. But as you mentioned, my lord, we were busy commencing with the evidence pertaining to accused number 2.
Sizodlula ke manje lapho sizoqala ke ngobufakazi ke mayelana naye ke umsolwa wesibili.
Right. Now, Brigadier Gininda, you've already confirmed your testimony in the trial within a trial, in which you also testified about the circumstances under which
Just imagine the audacity, the liver, okay, the sibindi of a mere policeman, okay, saying that 2% of the DNA was enough for him to run and say that accused number 3 was in the house and therefore 100% there were intruders. A mere policeman. That is what he said. Shout out to Umnisi for objecting, because we've been traumatized, okay? We've been traumatized for a whole 24 hours plus with Brigadier Gininda running the courtroom, and finally, the defense takes up an issue. Finally, oh my goodness. And did Mnisi not pick the right moment to bring it up? And thank you and shout out to Queen Shalolo as well for backing it up, because she saw the judge is not going to do a ruling. Did anybody else notice the judge still did not do a ruling? And then Baloyi said, you know what, let's just save time. Baloyi was avoiding the judge giving a ruling on it. And but Baloyi was also quite shocked when Gininda went into the 2%. Did you see his facial expression? Total shock. Go back and see it. But wait, that is not all. Baloyi says, you know what, let me be smart about this, let me be sneaky, let me not give the judge a chance to do a ruling, let me quickly transition to accused number 2. And Gininda said, we are not going to no transition. We're staying right here. I need to talk to Mnisi one-on-one as my colleagues. He's not your colleague. No, sir. No, he is not your colleague. He runs his own law firm. Currently, right now, being paid by legal aid. You, sir, fall under the Minister of Police at the South African Police Services and are paid under that budget. Let us not get confused. That is the problem with this LLB student who thinks he's already qualified. Meanwhile, Dr. Sibanda, silent as a church mouse. Oh my goodness. Kuningi, drop it in the comment section down below. But no, we will not say tima to Mnisi. We've got to put more firewood in the fire because Gininda needed to be placed in his spot. This is how it ends.
But we were busy commencing with the evidence pertaining to accused number 2.
Sizodlula ke manje lapho sizoqala ke ngobufakazi ke mayelana naye ke umsolwa wesibili.
Right. Now, Brigadier Gininda, you've already confirmed your testimony in the trial within a trial, in which you also testified about the circumstances under which accused number 2 was arrested.
That is correct, my lord. But if the court can give me indulgence, my lord, I just want to say, and I'll request the court, perhaps, my lord, to assist in that what was said by Advocate Mnisi, because that's exactly how I'm viewing it. It is insulting. For him, the word nonsensical or nonsense may mean something else if interpreted. But I think the context of how it's said may give a different meaning. I feel it's insulting and disrespectful. I don't think I've done anything contrary to being respectful to Advocate Mnisi ever since we started to deserve that. And I just want to request that we maintain the decorum of the court. We may differ with what I say. He will have the opportunity when he cross-examine me as to why I said that, why did I base those expertise, and challenge me on it, my lord. And the court will then make a ruling. I was simply making my observation, not testifying as an expert, to say these were the pointers that convinced me that they were intruders. Not that I was saying, my lord, the expert or whoever did the work were wrong or right. I was simply saying, after the matter was given to me, I had to analyze and make a decision as to whether indeed there were no intruders or were there intruders. And if there were no intruders, my lord, I would have given the same evidence to say, this is what I have, this is what the DNA is saying, and based on that, I was then convinced that there were no intruders. But in this instance, I'm simply pointing things that convinced me that they were intruders, not that I'm reinterpreting or testifying on behalf of the expert. It's simply that, my lord. But the mere point of my statement, my lord, is just to request that we treat each other with respect. That's all, my lord. The difference is, I know we will bump head with my colleagues because we're on the opposite sides. But at the end of the day, it's nothing personal. It's in the interest of justice and to help this cause to come to a just conclusion, but not to treat each other with disrespect. That's all I need to ask, my lord.
Okay, enough said. Can we adjourn for tea? I'm told it's 20 past.
Oh, okay, that's good. Please.
Okay.
And those are the only words from Judge Ratha. Enough said. Enough said. That is all he said after that whole mouthful from a brigadier. All I ask is that my colleagues respect me. We're on opposite sides, but please respect me. I'm a brigadier. Judge Ratha, enough said. Let's go for tea. Oh my goodness, I loved it. Thanks for watching. You know the house rules. And thank you. Catch you on my next upload.